Good afternoon, this is Sean Golding with Golding & Golding, here to do a little 2025 update to a prior presentation, an article we did back in 2021 about reasonable cause, international penalties, and how to abate or avoid them. So reasonable cause is an important component for taxpayers either before they've been penalized, depending on their facts and circumstances, or after they've been penalized if they're trying to get penalty abatement or relief. So let's jump in and take a look. So in recent years, the IRS has significantly increased enforcement of offshore tax compliance and reporting. Primarily, this includes having to report certain foreign accounts, assets, investments, trusts, entities, etc. on various international information reporting forms. The FBAR is one of the more common forms, but it's not the only form. There's FATCA Form 8938, which is similar to the FBAR, only it's filed directly with your tax return. There's 8621 for PFIC, 3520 for gift, trust, and inheritance, 5471 for foreign entities. There are some other ones as well, but these are the key ones. So when we're talking about reasonable cause, it's a timing thing. There's two options, right? For some taxpayers who are non-willful and they want to get into compliance because they want to file late forms but they have not yet been penalized, they may qualify for the streamlined procedures, delinquency procedures, reasonable cause. Delinquency procedures and reasonable cause, it's kind of interchangeable depending on the facts and circumstances, but then they have to show reasonable cause when they make the submission. That's before someone's been penalized. Alternatively, someone may have already been penalized and they want to get the penalties abated, just means removed or done away with, and so then they can also submit a reasonable cause statement as part of an appeal, collection, due process hearing, protest. You want to show that you had reasonable cause and not willful neglect. Common situations as this comes into is when someone has foreign income, for example. They may have been penalized for failing to report investment income, earned income in association with having a foreign entity that they work for, or they received a foreign gift, trust, and inheritance and received or may receive a large penalty. They've got bank accounts, investment accounts, securities accounts, mutual fund accounts, ETFs, CCOVs, all those types of things. And pension. A few years back, maybe 5 to 10 years, give or take, the IRS published an article about what needs to be reported and what doesn't, and it gives the impression that foreign pension plans don't need to be reported, but in fact they do. Your Australian superannuation, your Singaporean CPF, your Maltese EPF, your Hong Kong MPF, and India EPF, they're all reportable. And so a lot of people don't realize that till later, and then they want to file, and they either don't want to pay a penalty or they've been penalized. So how do you show reasonable cause? The first thing to consider is, unlike a streamlined submission, let's say, reasonable cause, there's no specific form. It's basically totality of the circumstance where a taxpayer wants to put together a typically 3 to 4 page letter submission that details someone's background, why they didn't report, why they're otherwise good taxpayers. Some facts are important. Do they file taxes every year if they're supposed to? Do they pay taxes every year? How many times have they had to file this form in the past? Had they not filed it several times? Did they just miss one time? You look at all these facts and then you put it all together and you go, okay, you want to prove this or present it to the IRS and persuade them to not issue a penalty, or if they've issued the penalty, to offer penalty relief. So some ways you can show reasonable cause is ordinary business care and prudence, serious illness, mistake, erroneous advice, or reliance. Let's talk about the two latter ones, because those are some of the more common. A mistake was made. So typically, just making a mistake or ignorance of the law in and of itself is not going to avoid penalties, but if through the totality of the circumstance you could show why the mistake was made, the facts that go along with it, maybe you've only been in the U.S. for a year or two, you went to a CPA, you've been filing, then you decided to do it on your own, and then you made a mistake, and it's because the CPA previously made a mistake, and you only realize that now, and you want to fix it, things like that. Erroneous advice or reliance is a landmine. You have to be cautious. It's not as simple as you went to a CPA. You have to prove that CPA or that tax professional, tax preparer, had knowledge of the specific type of area that you made a mistake. For example, let's say you fail to file Form 3520, foreign gift, large inheritance, right? If you had a CPA and that CPA touts themselves as an expert in international tax and they're telling you don't need to do it, that's going to go a long way to help support your case. If you go to a CPA and they go, I have no idea, I don't think you have to report it, right? There's no tax implications, just a gift, and you go, okay, and you don't look into it any further. Depending on what the background of the CPA was, it may impact whether you'd qualify for reasonable cause. Whereas in the latter example, the former example, when someone has that experience and gives you incorrect information, well, that will go a long way in helping support a reasonable cause statement. We have a ton of free information available on our main website and our sub-websites regarding reasonable cause. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter. It's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.